Thank you. So I take you now from intermediaries to divorce. I take it most of you have heard of this term, conscious uncoupling. So when Gwyneth Paltrow and Chris Martin decided to have a semi-split, they said they still love each other very much, but they needed to be separate. This seems to me a very good point analytically in thinking about patent law and human rights. So I'm going to be taking you a little away from what we've been discussing all morning and afternoon. And interestingly, for my purposes, uncoupling is something that one party can engage with independently to complete the relationship. So my task in the next 20-25 minutes, I'll try and be brief, is primarily two things. To talk about human rights and patent law seems to me to use human rights as a placeholder that takes attention away from root causes of systemic injustice. Secondly, talking about patent law and human rights together takes us away again from a sort of epistemic sickness in patent law. And I will back that claim up. The whole conversation about patent law and the right to health as a human right has been, really helped by the transnationalization debate, where, the transnationalization talks about different legal orders that talk about a single issue. So we're talking about health, both from the point of view of patents and human rights. But implicit in transnationalization, I think, is this idea that global rules impose norms from the top. Rather, a key part of what I'm going to claim is that the constriction that we see in transnationalization really comes from bottom up, from patent offices up. Okay, so what are we talking about? Just as a reminder, and I think it bears value to remind ourselves, last week, most of my examples I've tried to use are from either the UK or US, because I think we also need to move away from this debate as being something that's very specific to developing countries. Last week, there was evidence found of collusion between Actavis and Concordia on the price of an off-patent drug, which from 2013 to 2016 moved up 80%. This is an increase from 2008 of 12,000%, where the price of one pill of hydrocortisone went from 70p to 88 pounds paid for by the NHS. The third example, 6 million children under the age of 5 this year will die in low-income countries in conditions of extreme poverty, almost all of these due to preventable or treatable diseases. Okay, to sanity. Patent rights and human rights, where patent rights and human rights are in conflict, human rights must prevail. Now, this is a statement that Farida Shahid, who's the UN Special Rapporteur on Cultural Rights, made in her report on patent rights in 2015. And of course, this statement, I will come back to this statement further along my presentation. This statement, of course, assumes that patent rights and human rights are positioned in one system of law, such that when there is a conflict, one can trump the other. The statement in itself ignores the fact that one is tied to trade rules that can be enforced through dispute settlement bodies, and the other, human rights, is really subject to infelicities of expression and uncertainty in what can trigger intervention. I do spend a lot of time on Twitter, but I was very happy to see, and often when you go on Twitter, you find things that speak to what you're thinking about, at least in my experience. This idea of human rights as a form of morality and human rights law, I think, is something that we need to be very careful about. So part of my goal in the first sort of 6-7 minutes is to dissociate the two notions and be very clear about what we're talking about when we talk about the potential conflict between patents and human rights. Okay, so there's a vast amount of literature on this. So the human rights approach can be broadly divided into two approaches or two perspectives. The orthodox approach, which presumes universality, and the political view that sees these rights as triggers for intervention or as benchmarks for political legitimacy. The orthodox view does a lot of work for us. So the orthodox view and the presumption of universality that goes with it has been tempered in the last few years in the scholarship, such that the gap between the orthodox view and the political view is, I think, they're getting less polarized. There are philosophers like Joseph Raz, for instance, who points out that if you tie yourself to a universal notion of human rights, then you raise the bar for these rights in law. Because for Joseph Raz, the idea of a universal moral right is only relevant insofar as there is a right in a form that can be claimed by others, which would then imply an entity that has a duty to secure that right. I'm also interested in the deeper sort of work that this distinction between the orthodox view and the political view does for us. I see two kinds of work that it does. So those who find it difficult to tie themselves to a universal idea of human rights seem a little happier to tie themselves with the universality of the object of these rights. So again, Raz, for instance, says the whole human rights approach is about a commitment, an underpinning commitment to the value of life. But of course, in contemporary world, the most conspicuous fact about the contemporary world, I think, is that some lives have very much more value than others. So this is problematic. The second sort of work the orthodox view does is that it indicates a pure version of these rights, a sort of non-political creed that everybody can sign up to and feel happy about. A non-political creed that is not subject to bargains or compromises and is untainted by the political world. But again, and Samuel Moyne talks about this in detail in his book, The Last Utopia. And he says, human rights have succeeded where other utopias have failed, such as communism, have failed because of the moral bankruptcy of these utopias. But again, any notion or any work that the orthodox view does on this level has to take account of the voracious rise of capitalism, the privatization, deregulation, and the pullback of the welfare state that goes along with it. So what does the political view do for us? And where are we in terms of the sort of current thinking about it? One thing that really feels very relevant to me is what role can any universal notion of human rights play in the political view? And then we come to this, what is called as the mirroring view. Does a legal right, such as the right to health, assume that there is a universal moral right that is backing this legal right? And conversely, if there is no legal commitment, does it mean that there is no underlying moral right? The general consensus seems to be that there is autonomy between the moral view and the legal view, partly because this strengthens the legal view, because that distinction allows you to call upon triggers for legal intervention. But in the context of the human right to health, both the watering down of the orthodox view through notions of modernity, for instance, watering down of the orthodox view, as well as the autonomy, I think really plays into a certain indeterminacy in the human right to health. So I see the human right to health really as suffering, sorry, I seem to have lost some material there, as suffering from indeterminacy because the presumption of the universality doesn't really translate very well. The commitment to the human right to health is fragmented, scattered over several indeterminate phrases. So Article 25 of the Universal Declaration speaks of the right of all persons to an adequate standard of living, including the guarantees of health and well-being. 12 of Article 12 of the Covenant talks about the right to enjoyment of the highest attainable standards of physical and mental health. And Article 2, which talks about the obligations of the states that sign up to the Covenant, uses notoriously elliptical phrases like progressive realization and maximum available resources. So the human right to health, to my mind, suffers with this language. There are those who argue for radical inclusivity. They will talk about well-being and mental health as being part of the human right to health. It also suffers from indeterminacy when we start including non-legalistic frameworks. So one of the most significant developments, I think, when it comes to pharmaceuticals and corporations has been the UN Guiding Principles on Business and Human Rights, which talks about the need for corporations to respect human rights. But it is non-legalistic. It's a guiding principle. This indeterminate, immature legal right, subject to these phrases that at the moment don't have very much content, coupled with the fact that the orthodox view can't really help us, and coupled with the fact that autonomy is here to stay between moral rights and legal rights, leaves us in a very precarious position, particularly when resources are scarce or when pharmaceutical corporations, such as pharmaceutical corporations' actions or inactions are under scrutiny. So where does this leave the human right to health? I think what the most we can say is that the human right to health falls back upon a generalizable view of the morality of human rights. It's a technique applied in international law insofar as it is appropriate to apply in international law, where assigning these rights to individuals is a way of aspiring towards these rights. But this generalizable view, contrary to the orthodox view where there's a one-to-one relationship, is really subject to practical or pragmatic constraints. So we are left with really a form of political moralism supporting the human right to health. And I think it's very important that we recognize this, because it is here that human rights then becomes a placeholder. It becomes a placeholder that takes attention away from the system, from systematic or root causes of injustice or inequality. So human rights then says, let's look at the abuses as mere anecdotes, specific sites of injury, rather than investigate what causes those injuries. And of course, if we do not understand what causes those injuries, then we have no real hope of relief. So instances like refusing or inability to use interpret compulsory licensing to take account of unaffordability, for instance, or to take note of the $89,000 per year price on the muscular dystrophy drug, for example, that's just newly come out, all seems like delinquencies, minor aberrations, rather than very much an innate part of the system. So this, I have painted a rather dismal picture, but from here I'm going to take us now to the two versions or the two forms in which you can think of patents and human rights as being connected. One is patent itself as a human right, and second is the grant or the post-grant exploitation of patent rights impacting on the right to health. Patents as human rights I can deal with very quickly, not because it's an easy topic, because there is a lot of scholarship on it. So Wendy Gordon and Rochelle Dreyfus, for instance, have analyzed this in detail and said there is no reflection of human rights law in patent law. Rochelle, I think, might have modified her view somewhat, partly in response to the UN Special Rapporteur's views, and I'll come to that in a minute. So when Farida Shahid flatly denies, so the UN Special Rapporteur flatly denies that patent can be regarded as a human right. But she does this not on the basis of any view of a moral norm, but she does this on the basis of the consequences of granting patents. patents can cause inaccess to technologies, to medicines, to drugs. And on this basis, she says, there is no human right to patents. Perhaps because of the certitude, Rochelle, in a recent paper says, yes, patents can cause inaccess. I'll read the quote. While patent rights are not the only way or even a sufficient way to promote future technologies, science is expensive. This goes back to the point that Richard Arnold raised in the morning as well about AIDS drugs. So much of the human right to health debate suffers from a facing off of patents as a human right and health as a human right. But from my point of view, and given the placeholder view of moral rights, this location, the grant and post-grant exploitation of patent rights, I think is very interesting. This statement where patent rights and human rights are in conflict, human rights must prevail, really then to my mind must be unpacked in the context of the creation of the law that talks about the grant or the post-grant exploitation of patents. I think the UN Rapporteur's statement also underestimates the, and I use this term advisedly, the technocratic disposition of patent law. What do I mean by that? Okay, specifically in the context of patent law, there are three things we can think of when we talk about the grant or post-grant exploitation of patents. We can talk about the creation of norms. Where are these norms made? How do they come to settle? We can talk about application, which is, again, where the rubber hits the road. How do you enforce these norms? Who enforces these norms? And the ends. And I use the ends both with a small e and a capital E, ends of patent law or the ends of one particular interpretation of a doctrine. Okay, let's take each in turn. The creation of patent rules and norms. So both WIPO and WTO are sites of formal rule creation. They begin out as soft law, and I can see Professor Cornish there, but Professor Cornish says they begin out as soft law, but they have Genevan bootstraps. They harden over time. They are incorporated into bilateral agreements or dispute settlement board decisions. And a norm that can seem contested or unsettled can quite quickly gather strength. But the problem with these locations of rulemaking is that the process can be long drawn out, subject to political bargains, and often the positions are bulked out with rhetoric and posturing and non-legalistic frameworks. We've talked about WIPO and WTO. I think we should also think of the EU as a site of norm making. And here's an example. I don't know if you can read that properly. Perhaps the most credible source of new norms was the recently published UN Secretary General's report on access to medicines. That report places at the center of it this idea of delinkage, where you delink the cost of drugs from the R&D that goes into the other drugs that don't get to market or fail along the way. Delinkage, so this is the language in a resolution in EU Parliament that was just passed on March the 2nd, which talks about delinkage. It talks about delinkage in the vaguest of terms. It restricts delinkage to antimicrobial drugs and poverty-related diseases. So a broad norm which potentially could have the ability to price open some of the things that we have no information about. How are these prices set, for instance, is then whittled down to specific sites of injury, such as poverty-related diseases. There's rhetoric is used, and also the term poverty-related diseases does another kind of work, which is to say, oh, that's the problem of countries over there that are poor, that have low income, and that have to think about delinkage. We don't have to think about delinkage, but I would argue that that's not the case when you consider that the NHS could have been paying 70p for a pill that it has been paying £88 for the last 8 years. Okay, so in terms of creation of norms, there is very little direction of human rights norms, finding a way into how these norms are set. A core part of my argument comes in the application, and in this case, I could extend this to other forms of application, but I want to talk specifically about one form, which is in patent examination guidelines. This is something that we don't really think of as patent law. So nominally, European Patent Office examination guidelines are not law per se. Okay? They're not law per se, so they're not subject to oversight, but nonetheless, they give rise to legitimate expectations. What do I mean by that? It is directed at the applicant and it is directed at the examiner. So if you want to get your patent, you better stick to the claim categories that are mentioned in the patent examination guidelines. And so there are a few copies of this paper, that my paper on the registration desk, I believe. So I discuss in that paper two particular examples of how patent examination guidelines are revised, edited, changed, morphed to settle previously controversial or contested standards into something that begins to feel like a patentability standard. In the case of diagnostic methods, for instance, a specific definition is given that is incrementalized over phases. Some of these increments go towards patentability, some go away from patentability, but on the whole, through a lot of linguistic techniques, this is a position that's taken towards granting of greater patents on diagnostic methods rather than less. Swiss use claims, I find them ludicrous, frankly. These are medical use claims where Swiss use claims have now morphed into medical use claims, and apparently you can have both types of claims on the same subject matter. How does this sort of movement of norms happen in examination guidelines? I call the process textualization, and some of the things we see both in how Swiss use claims have come to become the norm as well as diagnostic methods have been interpreted include things like an ahistoric presentation of text or an appeal to authority. So the EPO will say, so think of, this is the Technical Board of Appeal decision where this has been decided. It will list all the authorities that support its position, but not list those that went contrary to what it's saying in the guidelines. But not at this scale is what I'm arguing. There's a reliance on constructed and technical reference. So diagnostic methods is interpreted in a way that you and I would not understand in the common in the way we use English commonly. Some of this, of course, is about law, but again, it's about the scale and extent and degree of what we see as textualization. We end up with legal axioms that are very difficult to unpack. Scrutinizing them is going to take time and resources, so we end up using them. We've seen what's happened to computer programs. So for instance, computer program method claim is not a claim in the category of computer programs. Now, this is a position that has changed in the last few years, but nonetheless stays on the examination guidelines as a settled norm. There are other problems with application which would prevent human rights concerns from making its way into it. So for instance, the Indian Patents Act, Section 3D, which tries to prevent a patent on different forms of the same substance, has been touted by many commentators as having the ability possibly to reduce exclusive rights to these kinds of patents dramatically. But we see from empirical research that both in India and Brazil, these sorts of measures to cut down on trivial incremental innovations have been very poorly used. So the law exists on the books, but is not being applied, rather surprisingly, is not being applied in the way that we imagined. Again, the UN Secretary General's report on access to medicine talks about public health sensitive patentability criteria. There is no chance that is going to make its way into the examination guidelines. The EU parliamentary resolution, which I just referred to, talks about this, makes a reference to this, but then says, we urge we urge states to apply strict patentability criteria. Now, I don't think public health sensitive patentability criteria is the same as strict patentability criteria. Okay, where does this leave us? Patent law, because of the way the norms are created, because of the technocratic way in which decisions are made, because of the expertise that's involved in making these decisions, really builds a firewall around itself. It is very difficult to penetrate this form of decision making. And in terms of the ends of patent law or the consequences of patent law, the spaces, I think, for purposive or deliberative discussion on, the aim of patent law, for instance, it keeps shrinking, and it's something that we should bear in mind. In terms of ends, now, I am being deliberately provocative. A lot of our assumptions, like a lot of our assumptions about economics, is faith-based, the term that Paul Krugman uses for economics. So any questioning of the goals of patent law really is a questioning of the idea that technological innovation can lead to growth, and growth that we want or we can identify with. Specifically, for instance, we talk a lot about the incentive effect in the patent system. We know from psychological research and sociobiological research that the incentive effect doesn't really play out in the same way. So Dan Pink and Eric Johnson, for instance, really unpack the incentive effect when you have monetary incentives. What kind of creative work do you get when you have monetary incentives? It really works for the routine managerial sort of creativity, but if you want more sophisticated creativity, that incentive really doesn't get you very far. There is also a sense in which this form of technocratic decision-making, I think, purges any scope for reflexivity in patent law. And I'll give you one example. Again, there might be people here who might disagree. In the 2011 case, the first UK Supreme Court case, Human Genome Sciences was Eli Lilly, on industrial application of gene sequences, the court is asked to consider, for instance, the specific, substantial, credible utility taken from US patent law. The court goes into this in great detail and then says there are obvious risks in relying on US jurisprudence when considering the precise nature of the requirements of Article 57, which talks about industrial application. So refusing to transplant law from another jurisdiction. Then, surprisingly, to my mind, they go on to accept 15 principles on industrial applicability from the case law, from the decisions of the European Patent Office, despite the fact that the European Patent Office has been applying US law from almost 2002. So they don't inquire about the provenance of these principles, but they're quite happy to just transport them into the law. And this is to do about the deference we have for expertise, the deference that we have for this sort of very pointed decision-making. And I think that should be a matter of concern for all of us. So going back to the semi-split, is it time for the couple to separate? So there are two circumstances under which they could stay together. If there's no harm in the relationship, in allowing the relationship to continue, I think there is harm because it takes attention away. It displaces attention from... I think I've missed a slide. Okay. It displaces attention from the root causes that lead to these purported human rights abuses. Is there a value in staying together? I don't believe so, because this epistemic firewall makes for a very unyielding patent law. So staying together allows us to feel that these abuses ought to be corrected by human rights law, whereas if we can decouple them, then we can pay attention, we can name and investigate the weaknesses, the shortcomings of decision-making in patent law. With the coupling, we're left with a tool that says if we can't sort it out here, we'll sort it out with human rights law, which doesn't really work. So any couple that splits needs allies, friends, right? Are there any allies we can call upon? Possibly Global Administrative Law Project, which is talking about things like transparency and participation and oversight might have a role to play here. But again, I would urge caution. I've got two examples. Again, I've tried to keep it very contemporary. Both come from US law. So it's possible to write citizen petitions to the FDA in the US, where you take your concerns directly to the FDA about a patented product. 92% of these citizen petitions are filed by pharmaceutical companies to slow down competition. Before Obama left office, there were investor groups who filed shareholder resolutions in 13 pharmaceutical companies asking for detailed information about pricing. Last week, the Securities and Exchange Commission made a decision that this was ordinary business and therefore didn't have to be enforced by these pharmaceutical companies. So I have my doubts about that, but that remains one way of seeing how we can connect them. Okay, right on time, maybe even 5 minutes to spare. Where does this leave patent law and human rights? So human rights, the human right to health suffers from the autonomy of international human rights law from universal moral rights. The indeterminacy in the specific expression, I think, is a result of having to rely on this generalized background view of moral rights, which weakens the form, content, and possibility of intervention. I believe putting them together is a distraction from the deep investigative work that is required to break through decision-making in patent law. And by putting them together, we are left with instances of specific injury or specific abuse, such as patents on incremental innovation or the price of drugs. And this dilutes any ambition that we have for real change. Any real change can, I believe, happen only through a systemic retooling of patent law. Okay, I'll leave it there. Thank you.